I've spoken repeatedly about the unconstitutionality of most mask mandates. Recently, the Third Circuit Court of Appeals was asked to review 2 cases where people were punished for attending school board meetings while refusing to wear masks. Sadly, the cases, as described in the Circuit Court opinion, seem poorly founded, thus leading to decisions against the plaintiffs. I think a closer look will not only show the flaws in the cases, but help others build better ones in the future. So we'll do that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your rise and generation to be free. I'm glad you could join me today. These cases, they were both heard together at the Third Circuit, and they got my attention in part for what they were about, but they also got my attention for the foundation upon which they were made. I mean, mask mandates are kind of my thing. I'm all about litigating and commenting on mask mandates. But it's how these cases were put together that really, well, I guess kind of broke my heart. So let's go take a look at these cases. Before we start, I want to state that the COVID-19 mask mandates were not only unconstitutional, but illegal as well, as I will show later in this review. However, we need to start where the Circuit Court started, with their own assumptions in the cases Falcone versus Dickinson and Murray-Nolan versus Rubin. The court stated their opinion with some background on the 2 cases they were reviewing. On March 9th, 2020, New Jersey Governor Phil Murphy declared a state of emergency in response to the quickly spreading coronavirus known as COVID-19. As we now know, it primarily spreads through airborne particles that accumulate in enclosed spaces, respiratory droplets produced when a person coughs, sneezes, or talks, and occasionally through contact with objects contaminated with the virus. In order to perform a fair review, we must take into consideration what was known back in 2020, even though much of it has been proven false. We must also consider what is fact and what is opinion. For example, the court points to a statement from the Centers for Disease Control and Prevention about how COVID-19 spreads. However, nothing in the document referenced even suggests that there are studies showing that this is how COVID-19 spreads. This common knowledge may be based on some reason and logic, but that does not make it true. While later studies, such as the one known as the Cochrane Report, found that, in general, masking made little if any difference in the spread of SARS-CoV-2, which is the virus that causes COVID-19. Individuals infected with COVID-19 can spread the disease while asymptomatic or pre-symptomatic, making the virus difficult to control. Once again, we see decisions being driven by assumptions that later turn out to be untrue. For example, asymptomatic transmission of COVID-19 was published in December 2020 and stated, earlier estimates that 80% of infections were asymptomatic were too high and have since been revised down to between 17 and 20% of people with infections. How are people supposed to make informed decisions with so many opinions being treated as scientific facts? In part because of these assumptions, Governor Murphy took several steps. Over the course of the ensuing months, Governor Murphy issued a series of executive orders to monitor and curb its spread. One of them mandated that New Jersey schools maintain a policy regarding mandatory use of face masks by staff, students, and visitors in the indoor portion of the school district premises, except, for example, when an individual qualifies for and obtains a medical exemption. In preparation for the 2021-2022 school year, New Jersey school districts, including the Freehold Township and Cranford Township school districts, implemented mandatory indoor masking policies consistent with the executive order. Both Mr. Falcone and Ms. Murray-Nolan objected to the New Jersey mask mandates in school. Both attended school board meetings unmasked, were confronted by members of the board, and threatened by the board with contacting law enforcement. Both stated that attending the board meeting maskless was constitutionally protected political speech and that the boards had retaliated against them for it. Mr. Falcone by the board canceling subsequent meetings and Ms. Murray-Nolan by her being arrested. Both eventually sued their respective school boards and law enforcement under 42 U.S.C. 1983, civil action for deprivation of rights, and New Jersey Statute Title 10, Civil Rights, 10, Section 6-2. In Mr. Falcone's case, the district court dismissed the amended complaint on the ground that Falcone had no standing to sue. It found his alleged injuries, the receipt of a summons and the board's meeting cancellation, were not traceable to the BOE or police defendants, but instead to Governor Murphy's executive order that the board had to obey. It followed, in the district court's view, that Falcone's alleged injuries also were not redressable by injunctive relief because an injunction directed at defendants would not enjoin the governor from implementing or enforcing a mask mandate. Now, the circuit court reversed that decision on standing and remanded the case back to the district court. In Ms. Murray Nolan's case, the district court rejected the Cranford defendant's standing arguments but agreed Murray Nolan failed to state a claim for First Amendment retaliation. Her alleged right to appear at the board meetings without a mask was not inherently expressive conduct, it reasoned, but rather was expressive only because she told defendants that it was and sued to prove it. The circuit court found, amid valid government-mandated health and safety measures, refusing to wear a mask is not expressive conduct protected by the First Amendment. Murray Nolan's retaliation claim also fails because the police had probable cause to arrest her and she does not link her constitutionally protected free speech activities, example, her social media posts, to any of the Cranford defendant's allegedly retaliatory actions. We thus affirm the district court's dismissal of her amended complaint. Now, in both cases, the plaintiff sued under both state and federal laws, claiming a deprivation of rights under the First Amendment. While the court focused on issues of standing, I see a much more fundamental issue with both cases, the claim of a First Amendment violation. That amendment reads, Congress shall make no law abridging the freedom of speech. Now, many people claim that the 14th Amendment somehow makes the First Amendment apply to the states, but the language of the 14th Amendment does nothing to change the language of the First Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In my opinion, that makes the foundation of both of these cases very weak. Now, they may have sued alleging violation of Article 1, Section 6 of the New Jersey Constitution, which reads, every person may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. That is still a weak argument, since in neither case was the plaintiff prevented from speaking. Rather, what we have here is a deprivation of both liberty and property without due process of law. From the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. While this argument can be laid at the feet of the school boards, it would more properly be extended to Governor Murphy. This would lead to a lawsuit under 1983, which reads, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected, any citizen of the United States or other person within the jurisdiction thereof, to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Let's look at the details of my argument for the rights of Mr. Falcone and Ms. Murray Nolan being violated. Let's start where this legal issue began, with Governor Murphy's executive order. The Constitution of New Jersey states, the governor shall take care that the laws be faithfully executed. Now, the governor of New Jersey has the power to make sure that the laws be faithfully executed. Therefore, for Governor Murphy's executive order to be valid, it must be allowed under New Jersey law. I am not an expert on New Jersey law, so let's assume that the law allows the governor to issue such an executive order. There's still one very serious problem with that mandate. It deprives people of both their liberty and the property they have in their own body without due process of law, which is defined as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Blanket mandates, such as those issued by the state of New Jersey, violate due process because they do not safeguard the rights of the individual. There is no requirement someone to be shown to have COVID-19, nor that they are contagious before their liberty is infringed. As shown earlier in this article, the assumptions that supported the mask mandates were not based on rigorous scientific studies, but unsubstantiated statements from government agencies that do not legally exist. The Constitution does not delegate to the United States the power to regulate health, food, or drugs. Furthermore, In the United States, the government is supposed to have the burden of proof before they infringe on your rights. Since no probable cause was established that Mr. Falcone or Ms. Murray Nolan were contagious and therefore a danger to others, requiring them to wear masks violated their liberty. Also, since wearing a mask can and does have an impact on the wearer, these mandates deprive them both of control of their property, namely their bodies. Even if we accept that at the time of these incidents, the medical establishment believed in the efficacy of wearing masks, the logic of mandates contradicts that assumption. After all, if masks were really that effective, why do they only work if everyone is wearing one? Since there was no due process either in the executive order creating the mask mandate or in its implementation, then the government-mandated health and safety measure was not, as the circuit court claimed, valid, and the school districts were not required to enforce them. Now, since 42 U.S.C. 1983 states that every person who, under color of law, deprives someone of a right protected by the Constitution or laws is liable, that would include not just the governor, as the court stated, but both the board members and law enforcement as well. I'm not saying this argument would have ultimately brought about a different outcome for Mr. Falcone or Ms. Murray Nolan. However, imagine the scene where they entered the board meeting without masks. What if rather than a general claim of speaking masks as being a constitutionally protected right, they could have provided both the board and law enforcement with a simple 1 to 2 page document pointing out that the governor's executive order was unconstitutional and therefore void. As the Supreme Court has stated, an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protections. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. What if they could have stood in front of their boards and not only articulated their points in detail, but provided evidence, both constitutional and judicial, of the rightness of their points? What if, should law enforcement still have been engaged, they could show not only the unconstitutionality of the acts of the governor and the board, but their criminality as well? Again, from the Supreme Court, an unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment. Would the outcome of their situation have been different? We will never know. However, I, for one, have found that a well-reasoned and supported case, especially with documentation, can have a profound impact on those we are trying to persuade. As I've said many times before, I am not an attorney. I don't pretend to be one. But I do study the Constitution, and I get very frustrated when I see cases that have some really merit, really ruined by a poorly defined argument. This never was a First Amendment issue. Even if you put aside the jurisdiction of this fact that the First Amendment says Congress shall make no law, neither of these people were prevented from speaking. They claim they were retaliated against because of what they said. That's a pretty weak argument. I wonder, did anybody actually consider the deprivation of rights that the mask mandate was? Didn't look like it from what I saw. Maybe there was, but I didn't see it. It's why I say it's not good enough for you to simply stand up. If you want to be effective, you need to have a well-reasoned argument. You need to have your argument, your position based on a solid foundation, not shifting sands. It's one of the key points in the boot camp for the Patriots program. Simply go to constitutionstudy.com/Patriots to find out more about that, and then click the link to take the boot camp. It's free, and you'll learn why having a well-reasoned argument works. And I will show you examples from my own life where having a well-reasoned argument made the difference. Granted, I wasn't standing in front of a court, but I was standing in front of the FBI. I was chatting with the U.S. Attorney's Office. It makes a difference. That's what part of what the Patriots program is for. It's part of what the Constitution Study is for. The Constitution Study is really about how do you prepare to defend and assert your rights. The Patriots program is meant for people who want to go deeper. Now, while you're at the website, constitutionstudy.com, hey, maybe sign up for a mailing list, buy one of my books, donate to the cause, whatever you can do to support the work that we're doing. Right now, the Constitution Study basically runs out of my pocket. So anything you can do to help means I can spread the word more. Whether it's sharing information, inviting me to come speak, or helping with monetary funds so I can spread the word myself. This is information I think people need. And they'll only get it if we work to share it, if we work to spread it ourselves. People like to say that knowledge is power, but I disagree. Knowledge is only power when it's put into action. Now, whether you put it into action yourself or you decide to help me put it into action, let's make sure that we are taking this knowledge about the Constitution and using it well to the defense of not only our rights, but the rights of others. If that's something you can get behind, I hope you will come back next time for the Constitution study.
Love the neighbors and have a few good friends.